Ms. Murray, is the yeah, you wish to represent yourself, is that correct?
Yes, ma'am.
And you do not wish to speak to Ms. Armstrong. Ms. Armstrong is a well-trained attorney who is best able to assist you with proceedings such as this that can be quite complicated. It's the court's recommendation that you take a moment and allow her to at least speak with you. I understand that you did not wish to, but I do think that that would be in your best interest. Are you declining the services of the public defender's office today?
I did, but if the court is recommending it,
The court is strongly recommending that you speak with Ms. Are you able to do that?
yes, I can.
All right. Is there a number where Ms. Armstrong can give Ms. Murray a call?
She can dial 404-612-2392.
All right. And Ms. Murray, please speak with Ms. Armstrong cooperatively. She's only there to assist you, okay? All right. Who do we have next?
Position 3.
All right. Are you Mr. Burgos?
Yes, ma'am.
All right, your case is 23 CR 003107E. In this case, you're charged with 2 counts of battery family violence with the offense date of April the 7th. Do you understand your rights?
Yes, ma'am.
All right. Mr. Howard, can I have his history, please?
His 5th arrest. Last arrest was back in October for battery DV. That's an open pretrial case. I think it's like 3,000. I forgot. 22 CR 007024E. 2018, 2017, and 2020 assault dismissed. That's it.
Good. Ms. Falk, please proceed.
Yes, Your Honor. First, I'd like to say that pretrial is correct. That is a $3,000 signature bond through pretrial, which the state would be asking that pretrial essentially revoke that bond. Additionally, we have the 2 cases, the 2020 domestic aggravated menacing and possession of a firearm, which was null prost in 2020, and the domestic assault, which is null prost in 2019, are both out of Delaware. We would further also like to put on the record that 22 CR 007024E case involved the same victim, in this case, Aaliyah Kuntz. So that being said, this incident happened April 7th at 55 Maple Street, apartment 106. Miss Aaliyah Kuntz was inside the leasing office with a severe laceration to her eyebrow. She did have excessive bleeding. Miss Kuntz initially told the officers that something fell on her while she was inside the apartment, and she didn't remember what happened or how she got to the leasing office. However, Miss Carmen, who is the leasing manager, kind of filled in a little bit of the blanks. She stated that Miss Kuntz rushed inside the leasing office requesting help, and that she stated that the defendant, who's the father of her children, got into an argument with her, picked up an unknown metal object and struck her in the head. Miss Carmen further stated that she called the police and saw a defendant who stated he was tired of Miss Kuntz putting her hands on him. Miss Carmen stated that she had never seen the defendant be this aggressive or in this much of a rage. She also stated that Miss Kuntz kept telling the defendant to leave until law enforcement arrived. Grady said that due to the excessive bleeding to her head, that Miss Kuntz did have to go to Grady. And when the officer followed up with Miss Kuntz about her memory, Miss Kuntz did admit that she was hit with something inside of the apartment, but she said the defendant is under a lot of stress. She needs him right now, and he takes care of the bills. So, Your Honor, I cannot emphasize enough what kind of position this puts Ms. Kuntz in. It is a very dangerous position for her. And what is particularly frustrating for the state is this defendant in that 22 CR case was not only given a $3,000 signature bond through by Judge Morrow, which we believe was incredibly generous considering the circumstances, but also had a no further contact order with Alicia Kuntz. The mere fact he was in that apartment at all is a violation of his current outstanding bond that he was just given on October 17th of 2022, which involved, incidentally, lacerations to Ms. Kuntz when the defendant struck her. So based upon the violation of the current outstanding bond and based upon the fact that this is now a serious risk of reoffense and a danger to Ms. Kuntz, we are requesting a $6,000 cash bond. That is going to be $3,000 per charge. Stay away from 55 Maple Street, apartment 106, and no further contact with Aaliyah Kuntz. We would like to sound for her to see if she is present.
All right, Ms. Kuntz, are you present on the Zoom conference and wish to make a statement?
I'm definitely present. I do wish to make a statement.
All right, hold on. Oh, wait. Hold on.
Sure.
We need to turn your camera on. I know that we had you muted and all right. You're gonna raise your right hand, please.
I'm sorry.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Today, I'm not imposing any sentence on Mr. Burgos. You can put your hand down. Thank you. What I'm getting, the facts of the case are not as critical as to your request to have contact or whether you have fear of the defendant. At this time, that is what the court is most concerned with in your statement. That said, what would you like to tell me at this time?
All right. So the situation is I was in the room with him. You know, we were having an argument, but I turned to leave to go to the front office anyway, because I actually had to talk to them. He threw back a trampoline, which he had sitting on his shoulder. He threw it backwards so he could put it down. It was a trampoline that got unwrapped, the rubber part at the top, you know, like a toddler trampoline. So what happened is I'm like, well, is this what's going on? I did go down to the front office. I did request her help because I just couldn't find my phone and my eye was bleeding. But unfortunately, he didn't even see me. And then he went to drop the kids off at the office because he was upset and he just wanted to leave. He finally saw me. He said, oh my goodness, I don't want to go back to jail. I said, you know, I need to leave the scene. That's what he said. I said, now, wait a minute. You got to stay right here with me. You got to explain to the police what's going on, or they're going to make up all this stuff. So Miss Carmen is actually, what's so funny is Miss Carmen, my building manager, is actually on video saying that she didn't say anything. She didn't do that. You know, I'm going to talk to her later. But the thing is that I believe that she lied or she got the story wrong because, you know, it was a lot going on and I understand her position. The thing is he never did anything to me. He never hit me. I feel safe. He can come home. I did tell her that he does take care of the bills, but it had nothing to do with the situation. Not you, but people need to understand I'm a grown woman. I'm competent. You know, I'm cognitive. If he ever hit me and I felt like he was trying to hit me like that, I would call the police personally myself. But I asked her to call the police and the ambulance, or I asked her to call the ambulance. Then she decided to call the police. All right, I guess the police came with the ambulance. And I felt like the police were trying to convince me, or the hospital staff social worker was trying to convince me he assaulted me. They put it in the system as assault. So I understand. I couldn't find the police report that they actually gave to me to call and like give them the proper story. So I understand what they might have thought. And, you know, the other day, I'm not really sure what's going on, but when the police picked him up, it was really embarrassing. It was really emotional. It happened in front of my kids. It was for no reason. I'd say I do understand, but all of these charges in the past that were let go of, they have nothing to do with me. I don't even remember this stuff. We've been married for 6 years. He's getting promoted as a manager for day shift at the job because he burns out. Sometimes he gets tired, and sometimes the neighbors, you know, have complaints, you know. So I believe that this was something that was built up and that people really don't like us because of certain reasons that are personal. You know, like I make people do what we asked them to do. Like my neighbor had to move out because she was harassing me.
Okay.
You know, that's what I'm saying. I feel like she's against me, and that's why she said it like that. I'm glad you told me that. Thank you so much.
All right. I do appreciate you coming to court and making that statement at this time. Ms. Wills, please proceed.
Thank you. My client is 25 years old. As it was stated, this incident did occur back in April of this year, and there have been no other reports of arrests or violence since that time. My client reports that he has been in Georgia for the past 3 or 4 years. He is married to the alleged victim in this case, and she is a stay-at-home mother. He is employed at Restaurant 10 as a head chef, and he has been there for the past 1.5 years. My client reports that he did not know that there was a warrant that was taken out on that date. And he also denies the allegations as alleged. We do understand, and my client understands, that he is currently on bond, where Ms. Burgos is the alleged victim in that case. I would ask for $1,000 surety bond. At any rate, Your Honor, I would absolutely ask for a surety bond as opposed to a cash bond in this case. My client would not be able to afford a cash bond in this situation. Thank you.
And Your
All
Honor, if I may, just very briefly.
Very briefly, Ms.
Very
Faulk.
briefly. I just
Yes.
want to point out that tampering with a witness is a crime. So I would advise Ms. Burgos against going to talk to our witness in this case, Ms. Carmen, or trying to discuss her testimony with her or change her testimony, because that is considered a criminal act in Georgia. Thank you.
Well, all right. All right. Okay, Miss Coons, you're muted, and we've heard from you. Just, it's very interesting that that's all transpired this way. Okay, here's what's going to happen. Judge Morrow's bond is still in effect, so there will be a no contact consistent with that previous bond that's now been reactivated. So defendant is to have no contact with Ms. Coons and stay away from the incident location. He can return one time with a member of law enforcement to get any items. He's going to receive a $10,000 surety bond. It'll be $5,000 on each count. Additionally, he's to have no alcohol, drugs, or weapons. Is there anything further from either party? Ms. Kuntz, we've heard from you. The best thing for you to do is to call Ms. Wills with any questions. I'm assuming the state and the defense don't have anything further?
No, Your Honor, just the stay away from the address. That was actually not part of Judge Morrow's original order.
Okay, so the original order was no contact, but there was no stay away?
We did not see a stay away or an address.
All right, what is the address alleged that he needs to stay away from, Ms. Folk?
The address is 55 Maple Street, apartment 106, according to our report.
Okay. Okay, I believe that there's nothing further. Ms. Coons, please give Ms. Wills a call. She should be able to assist you. All right, best of luck to you all. All right, who do we have next?
Judge, can we revisit position number 13 and 17? Your lady said that they do work together and no further contact would be a problem.
Okay, so they are not having any contact outside of work
Okay.
to the extent that it can, if they happen to see each other at work, that is what it is, but they're not to have any direct contact other than for work purposes.
Okay, thank you. Position number 16 is ready.
Ooh, let's try not to go back on a day with 23 positions. All right, Ms. Murray, your case number is 23CR003115J. You're charged with obstruction and theft by taking. You understand your rights today and that you do have a right to an attorney, but you're declining the services of the public defender's office. Is that correct?
No, Your Honor, I don't comprehend. I did refuse service of the public defender, Ms. Armstrong.
Okay, you understand you have a right to remain silent. Anything you say to me, the state is listening and they will use it against you. By using an attorney, you're more likely to be able to preserve your right to remain silent. And again, like I advise you, you have a right to counsel today. Do you and you wish to move forward without an attorney and represent yourself?
Can you repeat that, Your Honor?
Okay, let's try this again. You have a right to remain silent, right? You understand that?
I do comprehend.
Okay. Anything you say is going to get used against you. If you tell me something by mistake, the state could turn it into another charge. You understand that that could happen.
Okay.
And if you choose to represent yourself and you're saying stuff to me as part of that representation, the state may end up using that against you. Do you understand that?
Question. If
I cannot give you any legal advice today, but what is your question?
if I remain silent, am I able to request a signature bond?
You can make that request. but I'm gonna listen to your history and the facts that's presented by the state. I cannot guarantee you, if all you're gonna say to me is you request a signature bond, you know, of course, that would be fine. That's not something the state can use against you. But if you end up telling me other things, the state may use what you say against you. You understand all that?
I don't comprehend is it like my own answer that they can use against me, or is it
Yeah.
just?
Yes, and your own answer can be used against you.
Okay, but I can choose to remain silent depending on the question.
There will be no questions. No one's gonna ask you any questions today, okay? I'm just saying, if you start talking to me and you say something by mistake, the state can use it against you. That's why people hire attorneys so that they don't have to answer questions and say things that could be used against them later, okay? If I have to ask you a question and you give me an answer, the state could decide to use that answer against you. You understand that?
But if you ask me a question and I choose to invoke like the Fifth Amendment, can I?
Yes, right, exactly. That is exactly correct. But then I'll have no information to be able to help you. Okay? You understand that? It's Miss Murray. It does not seem like you understand what I'm saying, and you are sure you don't want Miss Armstrong to help you.
I did speak with Ms. Armstrong like you suggested, and I still did not comprehend. So
Okay. Well, we're gonna move forward with the hearing. I feel apprised that you understand your rights enough. You understand that you are not gonna say anything. And if you say things, the things that you say can be used against you, and that you did have a right to have Ms. Armstrong represent you. Mr. Howard has informed me that this is your first arrest. So let's go to Mr. Young. Mr. Young, the facts as alleged.
Yes, Judge, May 16, 2023 at 2301 Delow Drive and East Point. Law enforcement there were executing a writ of possession. The accused, she arrived at that location while they were executing the writ of possession. They told her to not go in. She went inside, disobeying officer commands. There was a key in the door because CSS Labor was on scene, changing the lock to the door. She took the key, concealing it. It was later found on her person. The state recommendation is a $3,000 signature bond through pretrial services, $1,500 each. Stay away from that location, and no alcohol, drugs, or weapons while on bond.
Okay, in light of the facts before me, I'm gonna accept the state's recommendation, grant the signature bond. It said it will be through the jail. She's to stay away from that location and have no alcohol, drugs, or weapons. All right, best of luck to you, Miss Murray. Don't go back there, okay?
What's the breakdown on that?
I'm accepting the state's recommendation,
Your Honor,
You got a signature. You don't have to pay.
1,500 each account.
Thank you.
Thank you, Ms. Woods.
Mhm.
All right, best of luck to you, Miss Murray. Who do we have next?
Position 4 and 5.
All of them can't come to.
Okay, because of the nature of this, we probably can't do these all at once. So we'll gonna do position 4, 23 CR 0031088. In that case, you're charged with battery family violence with the offense date of August the 29th of 2022. And then you also have a second case, 23 CR 0031009E. In that case, you're charged with battery family violence and simple battery family violence with the offense date of December the 18th. Do you understand your rights? Is that a yes?
No, ma'am, I thought one of the charges had been dropped.
Okay, but let's not even get into that. I'm not speaking to the charges. Do you understand your rights today?
Yes, ma'am.
Okay, thank you. We can perhaps get into that in a moment, okay? Mr. Howard, can I have the history, please?
Is this Canty?
Correct.
Yeah.
Yes.
Oh, okay, my bad. 17 total. 2019 probation, 2019 simple assault conviction, 2013 possession of cocaine conviction, and an 08 simple battery conviction.
What was the 2019? I'm sorry.
Simple assault out of Cobb County, Your Honor.
Okay, thank you.
Yeah, and probation violation.
Okay, thank you. Ms. Falk, please. proceed.
And yes, Your Honor, we also had a 2015 probation violation as well. It is correct, the state did move to NOD one of the simple battery charges, but the remaining counts on Your Honor's calendar are correct. So this incident was two incidents that occurred with the same victim at 532 Cleveland Avenue Southwest, apartment 19A. The first incident happened August 29th of 2022. The defendant and Ms. Demetrius Adamson, who lives with him, got into a verbal argument. According to Ms. Adamson, the defendant was arguing with her about cooking and cleaning and wanted $5, and she did not want to give it to him, at which point the defendant struck her in the face with a closed fist. The officers did observe the bed in the, that incident happened on August 29th, and the officers did observe that her left eye was swollen and bleeding. The second incident happened December 18th, 2022. So approximately a little less than 4 months later, Ms. Adamson again called, or the police were called out to that address again. Ms. Adamson was interviewed, stated she was sleeping. The defendant entered the room, dragged her out of bed, and began slapping and striking her. She stated she didn't know why the defendant was upset when this happened. The officers did observe that in the bedroom, the bed was off its box spring. A table appeared to have been flipped over, and there was some property damage. The defendant stated that he confronted Adamson about infidelity and was arguing with her, and she assaulted him. Ms. Adamson was initially arrested. However, the officers did not originally see injuries to her, but her eye began swelling, according to the officers' warrant, exponentially, which began corroborating her statement along with the property movement and damage in the bedroom. So we had an opportunity to speak with Ms. Adamson, who I believe is on the Zoom today. She stated that she and the defendant are in a relationship. They live together at that location, and they do not share any children. She did confirm the events of the incident on August 29th of 2022 and stated she did go to the hospital and had her eye taped. She did also state she didn't remember the incident, all the events of the December 18th, 2022 incident, but confirmed that the defendant hit her in the face. She claimed that before this August incident, this had never happened before. They had not had any violence between them since the December incident. She is currently stating she is not in fear of him and wants him to return back to the residence. However, I would point out to Your Honor that he has that 2009 simple battery conviction, 2019 simple assault conviction out of Cobb, and now these two charges, which tend to show a risk of reoffense, especially when it comes to acts of violence. For that reason, the state is asking for a $7,500 surety bond. That's $3,000 is to each of the batteries, and $2,500 is to the simple battery. No further contact with Demetrius Adamson, no alcohol, drugs, or weapons. Stay away from 532 Cleveland Avenue Southwest, apartment 19A. That's all for the state, Your Honor.
Thank you. Ms. Adamson, if you're present and would like to make a statement, please unmute your screen and raise your right hand. We need you to unmute. Thank you. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury? We can't hear you.
Your Honor, it appears her screen wasn't muted. It appears her audio wasn't connected.
There was
was
a
not
camera
connected.
next to her for a moment. I mean, a
No.
little.
That was a phone. It looked like she dialed in on the phone side instead
Okay.
of on the phone. I asked her to log off all the way to Zoom, and when she logs back on to select auto for her phone, her feature is not featuring on her phone. You have to accept it and allow it. So she's not gonna be able to talk.
Okay. My apologies, Ms. Falk and Ms. Lewis. I thought it was microphone and not a phone icon. Okay. Ms. Adamson, did you hear those instructions? We'll need you to log off of the Zoom conference, come back on, and then join the Zoom audio so that we can hear you. Okay. All right, Ms. Wills, I'm sure that her testimony will inform your arguments. However, I ask that you try to proceed if you can.
Thank you, Judge. I have had the opportunity to speak with Ms. Adamson, and she did indicate that she was not fearful of Mr. Canty and that she did want him to return back home to the residence. Mr. Canty is 43 years old. He is originally from Georgia. He has a high school diploma. He does have 4 children. However, none of them reside in the home with him at this time. He reports that he is employed through R&S Construction as a brick mason. And he has been employed with them for the past 10 years. And he also works odd jobs. He does not have a lot of income, has very, very limited income. We understand that he does have 2 pending battery charges. My client reports that there have been no other incidents since last December. There has been no evidence presented that there's been any other incidents since this past December, which was 5 months ago. And it is my understanding that Mr. Canty and Ms. Adamson have resided together since that time. My client reports that they got together shortly after August. And so in light of that, Your Honor, I would ask for a signature on bond. Again, my client has very, very limited income. If Your Honor is not so inclined, I would ask for a $1,500 surety bond.
Was Ms. Adamson able to log back in?
She's coming back on now.
Okay.
Her auto's connecting now.
All right, Ms. Adamson, please raise your right hand.
Hello, can you hear me?
We can. Please
Okay.
raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, as I just explained in the last case that you may have watched, I'm not imposing any sentences today. So the
Okay.
facts of the case are not as critical as to your determination regarding contact or fear of the defendant. What would you like to tell me at this time?
Could you repeat that, please?
I just want to know, what would you like to tell me? The facts of this case or what you believe the state may have said wrong is not what I'm trying to get to. What I want to know is if you want to have contact with the defendant and your position regarding your safety. What would you like to tell me?
I do feel safe around him and I would like to continue to have contact with him.
Okay, is there anything else you'd like to tell me?
No, ma'am, that's it. Things have been okay with between he and I since those incidents. We've been working on trying to continue to make things better with each other.
Anything further, Ms. Falk or Ms. Wells?
Just briefly, Your Honor. Ma'am, you called the police 2 different times in October and December. Is that in August and December? Is that correct?
Yes.
Okay, and that was because you were in fear for your safety at those times.
No, I wasn't in fear for my safety. I just wanted us to not be fighting and also get medical attention.
Okay, that's all for the state.
Ms. Wells, anything further?
No, I would just ask that Your Honor take in consideration what Ms. Adamson has presented to the court today. Thank you.
All right. At this time, defendant will receive a $2,000 surety bond in the case ending in 3108E. He's to have no contact with Ms. Adamson and stay away from the incident location. Additionally, he's to have no alcohol, drugs, or weapons. He can return one time with a member of law enforcement to get any items. As it pertains to the case ending in 3109E, defendant will receive a $2,500 surety bond. It's broken down 1,500 count 1 and 1,000 count 2 with the same conditions. Is there anything further from either party?
No, Your Honor.
All right. Best of luck to you, sir, and you both. Let's we can move to the next position.
Position number 7, Mr. Dorsey.
All right, Mr. Dorsey, your case is 23 CR 0031118F. In this case, you're charged with criminal trespass and damage to property with the offense date of April the 18th. You understand your rights?
Yes, ma'am.
Thank you. Mr. Howard?
25 total. Last arrest was back in September out of Carroll County probation. He got an open terroristic threats. That's 21 CP 197545. Got a probation out of Carroll County for burglary. 2015, they gave him 10-year sentence, 3 to serve and 7 years probation. 2022, possession of marijuana conviction. 2021, probation. 2021, unlawful for an inmate to possess a controlled substance. Probation violations from 2020 and 19. Battery, 2018, and 2 counts of trespass conviction, 2018, and 2016 theft by taking conviction.
All right, thank you, Ms. Falk.
Your Honor, this incident happened April 18th, 2023 at 2500 Center Street, apartment C315. Angela Watkins is the victim in this case, and she stated that the defendant, her child's father, she asked him to return her apartment key because she was breaking up with him. The defendant came to her residence, broke her front window by throwing a candle through it, and kicked her door violently multiple times. Ms. Watkins also reported that her 9mm Taurus handgun was missing after the defendant had left the residence. There was a 1-year-old child, NW, who was present sitting on the couch when the defendant committed these acts. We would cite to that 2018 conviction for battery and criminal trespass out of Clayton, and the just lengthy history of probation violations in 2009, 2020, 2021, and 2022, all out of Douglas and Carroll counties. He also has a $5,000 surety bond for that terroristic threats from 2021 that is open here in Fulton County, and had a 2021 false imprisonment, battery, family violence, and criminal trespass, criminal cruelty to child in the 3rd degree, involving a different victim that was no prost on January 10th of 2023. Added up, this shows a defendant who is not likely to respond well to the court process and is a likelihood of reoffense. For that reason, we are asking for a $3,000 surety bond. Stay away from 2500 Center Street, apartment C315. No further contact with Angela Watkins. No alcohol, drugs, or weapons. We would like to sound for Ms. Watkins at this time.
All right, is Ms. Watkins present on the Zoom conference and wishes to make a statement? All right, hearing and seeing none. Ms. Wills?
Thank you, Judge. Mr. Dorsey is 27 years old. This incident did occur back in April. Mr. Dorsey reports that he is originally from Georgia. He does have 6 children and is currently unemployed, so he has a very, very limited income. He denies the allegations as alleged, and he was also unaware of the warrant. And he also denies that he was ever in a relationship with Ms. Watkins. I would ask the court to disregard any testimony in regards to any alleged theft, as my client has not been charged with theft or any cruelty charges, nor should he be discriminated against for any charges that have been dismissed against him. I would ask for a signature bond, Your Honor, or a $500 surety bond. This is a criminal trespass case. Thank you.
All right, defendant will receive a $1,000 surety bond. He's to have no contact with Ms. Watkins, stay away from the incident location, and have no alcohol, drugs, or weapons. Is there anything further? All right. Sir, I know that you have a question. I think the best thing for you to do is speak with Ms. Wills. You have a very limited question about the bond.
A lot of things that was brought up was false, like.
Okay, yeah, right. Don't respond to those.
Everything. I'm no longer on probation or nothing. I've never been convicted of no violent crime toward no kids or family violence or nothing like that.
Okay.
All charges was dismissed because lack of evidence, and that person is getting ready to get charged with perjury, false report of a crime, false statement, even making those type of charges. Now, as far as Angela,
Mr. Dorsey, I'm going to advise you not to remain silent. I would advise you to remain silent. You have a $1,000 surety bond. You'll be able to fight these charges at a later time.
All right. Best of luck to you, Mr. Dorsey. Can we please move to the next position? Who do we have next? I'm sorry, I can't hear.
You got position 8.
All right, thank you. Mr. Fitzhugh, your case is 23 CR 003116J. In this case, you're charged with battery, family violence, and cruelty to children in the 3rd degree. Do you understand your rights?
Yes, ma'am, I do.
All right, Mr. Howard.
8th arrest. Last arrest was back in April. Ag assault out of Clayton County. That's open. 2018 battery DV, criminal trespass, first offender. 2018 shoplifting NOLO, 16 failure to appear. 2015 possession of a knife or a firearm during the commission, selling marijuana.
Okay, thank you. Ms. Falk.
Yes, Your Honor, sorry. I'm just checking on that last charge in April. I thought it was an ag stalking. It is. So he does have an open ag stalking out of Clayton County from April 25th of 2023 that also involved this victim, the same victim in our case. We did get a chance to talk to Clayton County and were able to confirm that, as well as the fact that the case is open. So this incident happened March 29th, 2023 at 375 18th Street, which is the target, at around 5:53 p.m. Ebony De Silva stated that the defendant, who is the father of her child, assaulted her in the back of his vehicle in the Target parking lot. She stated that they were driving home, began arguing because the defendant thought she was not going to let him see his son. The defendant got out of the front seat, opened the door to the back of the vehicle, spit on her, and hit her in the head with his hands. Ms. De Silva, at the time of the incident, was holding their baby, KD, at the time. 3 women ended up stopping to help her, and one called an Uber to take her home, according to Ms. De Silva. She stated she left the scene, went to Paulding County Hospital. She did have to get skin glue to close an eyebrow laceration, as well as she had a swollen lip and contusions to her face. Officers then went back and retrieved the video from the Target around the same date and time of the incident. It does show a vehicle parking, an individual getting out of the driver's seat, opening the rear door and getting into the vehicle. A bystander then approaches the vehicle. Several more bystanders approach the vehicle, and then another person, we believe is Ms. De Silva, is seen getting out of the vehicle and then leaving in a different vehicle, which corroborates the statements of Ms. De Silva. We did have an opportunity to speak with her. She stated they are not in a relationship. They do not live together. They do share one child, which is the juvenile KD. She stated they've known each other for about a year. The defendant has been violent with her the entire time. She further stated that this is the first time the police have been involved, and she did confirm the events in the warrant. She stated that he would not stop hitting her even when the 3 women came over to tell the defendant to stop. And at the time, she was holding their 5-month-old child and got blood on her son from him hitting her repeatedly. She did state that she was told she needed stitches. However, because she was afraid of needles, she opted for the skin glue instead. She filed for a TPO in Clayton County, which was granted, which is what led to that aggravated stalking arrest in Clayton County in April. And she says she does not feel comfortable with the defendant being around her child because he assaulted her while she was holding the child. So she knows he doesn't care about their child, and she's extremely afraid of the defendant and fears what he may do if he is released. We would like to sound for Ms. De Silva. In the interim, we are asking for a $3,000 cash bond, no further contact with Ebony De Silva or KD, the juvenile, no alcohol, drugs, or weapons. That is due not only to the open aggravated stalking case from April 25th involving Ms. De Silva, but also there was a 2019 battery family violence where he did complete first offender and that case was closed. Ms. De Silva was not the victim on that case, however. That is all for the state.
Is Mr. Silva present and wishes to make a statement? All right, hearing and seeing none, Ms. Wells.
Thank you, Judge. Mr. Fitzhugh is 25 years old. He has spent the majority of his life in Georgia. He reports that he has an associate's degree in business, and he's currently in school for massage therapy through the Career Institute in Conyers. He does share a 7-month-old son with the alleged victim in this case. My client also reports that he is currently employed by AT&T as a sales representative, and he has been employed there for the past 10 months. Mr. Fitzhugh reports that he does not or was not aware of the warrant, and that he did turn himself in. He states that he and Miss De Silva are not living together. They are no longer in a relationship. He would have no objection to not having contact with her. And currently, he states that there has been a lot of back and forth with this alleged victim, and that there is currently a no contact order for both of them to stay away from the other at this time. I would ask for third-party visitation if Mr. Fitzhugh has any rights to visitation with his child. And I would ask for a signature bond, Your Honor. And if Your Honor is not so inclined, I would ask, instead of a cash bond, that'd be a $3,000 surety bond. I find it very curious that multiple people stopped and helped and called an Uber as opposed to the police. It seems like there's evidence that a dispute may have occurred in the parking lot, but not necessarily a battery. And so for those reasons, I would ask for a surety bond. Thank you.
And just to clarify, police did arrive at the target, so somebody called the police. And we would like to make that a $2,000 cash bond on the battery, $1,000 on the cruelty to children, 3rd degree. We did not do the breakdown, Your Honor. For that, I apologize.
Okay. At this time, defendant is going to receive a $5,000 surety bond. It's going to be $4,000 on count 1, $1,000 count 2. He's to have no contact with Ms. De Silva and stay away from the I guess not the incident location, but the shared home at this time. He can return one time with a member of law enforcement to get any items as necessary. He can arrange to see the child by coordinating with a third party should he have any visitation rights. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Your Honor, we would ask that before third-party visitation commences, he produce any documentation that shows he has right to visitation right now.
They're married as his child.
I don't believe
they
they are
married?
married, Your Honor.
They're not married.
No, they are not.
And my client has indicated that he has not yet legitimated, but that is something that he is working on.
Right, he's gonna have to do. Okay, so we're gonna comply with whatever visitation documents are put in place by court, and any evidence that he can provide that he has a right to visitation, then he can coordinate it with through a third party. That's a complex order, Ms. Lewis, so I may have to speak with you about the wording of that. But we are gonna require that he produce evidence that he has right to visitation. I know, Mr. Fitzhugh, that you would like to make a statement. I'm sure you disagree with the facts or with the bond as I've said it. However, I don't want you to make a mistake and say something that's gonna get used against you. What is your question?
I just have multiple, like you guys said, multiple situations where the mother and I
No, don't say those things, okay? Those things are, the state is listening, so you may, by mistake, say something about any of those incidents and it ends up being used against you. If you want to dispute the facts or clarify any points, the best thing for you to do is speak with Ms. Wills. Okay, I don't want you to talk about what may have happened in the past.
Well, okay, I understand now. Well, the police was never called, and they called the Uber instead.
Mr. Fitzhugh,
Okay,
Mr. Fitzhugh.
No, yeah. Ms. Wills has done a great job presenting your case, and you may say something that makes her job harder, okay? So please give her a call or seek private counsel after this hearing today, okay? All right, Mr. Fitzhugh, best of luck to you. But who do we have next?
Position number 9.
Hold on, guys, I'm sorry, this is Ms. Lewis. Is there still a one-time return for law enforcement? I noticed a stay away, but I was just questioning.
We can add that, yes, just in the event he does need that. Thank you.
Oh, okay.
All right, who do we have next?
Position number 9.
All right, Mr. Gilbert, your case is 23 CR 003110B. You're charged with simple battery. Do you understand? Simple battery family violence. Do you understand your rights?
Yeah, sure.
All right, Mr. Howard.
3rd arrest, 2018, misdemeanor possession of marijuana that was dismissed. That's it.
That's it. Okay. Mr. Young, please proceed.
Yes, Your Honor. This incident occurred on May 15th, 2023 at 1794 1 McClelland Avenue in East Point. The victim in this case is Tatiana Fernander, and we would ask the court to sound for her when appropriate. Law enforcement arrived at this location and witnessed all subjects yelling at each other. They made contact with the victim, who stated that there was a verbal altercation with the accused over Mother's Day. However, when officers spoke with two witnesses, one being Tamia Fernanda, the sister of the victim, stated that she and her boyfriend heard an argument that became physical. She attempted to intervene, but the accused was on top of the victim and they were grabbing at each other by the hair. Law enforcement also spoke with a second witness, Sakaria Harge, who stated that she and her girlfriend heard screaming. She entered and observed the accused with his hands around the neck of the victim. A victim advocate spoke with the victim, who denied that anything physically occurred. However, Your Honor, there was two witnesses on scene that stated that there was a physical altercation between the two. Based on the facts presented, the state does have some concerns about the safety of the victim. So with that being said, the state's recommendation is a $4,000 surety bond, no further contact with the victim, stay away from the incident location, 1 day anger awareness, and no alcohol, drugs, or weapons. You can sound for Ms. Tatiana Fernanda if she is on Zoom when appropriate.
All right, is Ms. Fernanda present and wishes to make a statement? All right, hearing and seeing none, Ms. Wells.
Thank you, Your Honor. Mr. Gilbert is 23 years old. He is originally from Georgia. He does have some college, and he does have a 3-year-old daughter with a child on the way. He reports that he is currently employed as a manager for LA Choose, which is a restaurant, and he's been employed there since August of last year. My client, Mr. Gilbert, reports that this was a verbal altercation, that it never became physical, but does know and understand that it was the alleged victim's sister that did call law enforcement. My client also reports that upon speaking with law enforcement, which he initially did not want to do or declined to do, he was told that had he spoken with them at the incident location, that he would not have been arrested. And they also, Ms. Fernander also reported that to my client as well, that she was told that also. Mr. Gilbert states that nothing like this has ever happened before. He has very limited criminal history. I also tried to reach out to the alleged victim in this case. However, I was unable to contact her and left a voicemail. I'm asking for a signature on bond in this case, Your Honor, and if Your Honor is not so inclined, I would ask for a $750 surety bond.
All right.
Yeah, and if I may briefly add some information that was provided by the victim advocate, we did have contact with Ms. Fernanda. The victim, she is pregnant by the accused, and she wants contact. However, the state does have concerns about her, not only her, but the child she is pregnant with as well. So we would ask for the $4,000 surety bond with conditions.
Defendant will receive a $1,500 surety bond. He's to have no contact with the alleged victim and stay away from the incident location. He can return one time with law enforcement should he need to get any items from that location. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing from the state.
Sir, the best thing to do is speak to Ms. Wells. All right, what would you like to say?
Miss Fernandez is my fiance. 1, 2, she is pregnant with my child. There was no physical anything going on inside of the apartment. 3, we have active.
No, sir, I don't want you to dispute the facts. Do you have a question about the bond?
I do, and I have a question about the no visitation, because we have active doctor OBGYN visits, which I take her to and I pay for personally out of pocket. So, and for the sake of my child, I haven't missed any. With my first child, I didn't miss any doctor visit, and I wouldn't like to miss the second one because my first child is taken away from me. I don't have the chance to see it, so I don't want to miss the opportunity to be at the doctor visit for my child.
Okay. What's gonna happen is the case is gonna be reset to the state all-purpose calendar in 2 weeks. For now, the bond will remain as set. However, you and your attorney can appear at that calendar, and the contact provision can be revisited at that time. For the next 2 weeks, at least, it will remain as I just indicated. All right?
One more thing on the gender of my child was supposed to be set for today. And I was supposed to be knowing the gender of my child as of today in this incident.
I understand, but it's gonna remain as it is.
I'm saying,
All right.
me and her said nothing happened, so I'm confused on what's going on. It's her sister being mad about the situation. It's
Mr. Gilbert, I would advise that you remain silent. The bond has been set. If you have any other questions, you can call my office.
All right, best of luck to you, sir. Who do we have next?
Position 10.
All right, good afternoon, Mr. Gilles, is it Giles? Your case is 23 CR 0031. In this case, you're charged with criminal trespass and simple assault with the offense date of May the 16th. Do you understand, right?
Yes.
Mr. Howard?
Fourth arrest, 2021 trespass, 2014 probation. They had armed robbery up under that probation charge. That's it.
Okay, Mr. Young?
Yes, Your Honor. This incident occurred yesterday at 1960 North Avenue, Northwest in Atlanta. The victim in this case is a Gregory Casey. Would ask the court to sound for him when appropriate. Law enforcement responded to this location after Fulton County Marshals had evicted the accused. That day, the accused returned to the residence, entered the home. He held a knife in his hand and told Mr. Casey, who was present, do not approach me or I will be forced to defend myself, all while standing inside the residence he had been evicted from and having all his belongings removed. The accused then barricaded himself inside of a room at this location where law enforcement had to respond. You know, disregard the last fact. Anyway, the defendant's sister resides there, and neither she nor the victim want the defendant to return to this location.
Okay.
Okay, he did barricade himself. I had to clarify that. He did barricade himself inside of a room there.
Okay. It's a room within the house he barricaded himself inside?
Yes, well, law enforcement had to respond, and he came out with no issues, and they was able to retrieve the personal weapon that he had. So the state's recommendation is a $4,000 surety. That's $2,000 on each. Stay away from the incident location. No further contact with the victim, Gregory Casey.
All right, I'm signing for Mr. Casey at this time. All right, hearing and seeing Ms. Wills.
Thank you, Judge. My client is 30 years old. He has resided in Georgia for the past 20 years, and he does have family and a support system here. He has obtained a high school diploma. He does have an 8-year-old daughter and is currently employed as a mechanical technician. My client reports that he never received a notice of eviction, so he was a bit confused on this date. And he also reports that not only did he lose his housing, but he lost everything that he owns. And is absolutely in a tight financial spot right now. So Your Honor, if you would be so inclined, if he could have a signature bond or a $250 surety bond.
Okay. All right, I'm gonna ask, I apologize if I don't really understand the facts. He was barricaded within the room of the house as it is alleged. He was asked to leave, he walked out and then went back in. Is that correct, Mr. Young, or did I get this?
Let me see if I can simplify it.
Okay, yeah, I'm sorry, I'm struggling with this.
Okay. He had been evicted per the report by the Fulton County Marshals.
Okay.
And he left. After the eviction process was done, he returned to the residence and he entered the home. George Gregory Casey, I believe, is maybe the owner, and his sister is the one renting, but the locks were being changed. And he entered while that was going on. While Gregory Casey was there, Gregory Casey told officers that he did hold the knife in his hand, told Mr. Casey, do not approach me or I have to defend myself, and then proceeded to enter a bedroom in that home, probably the bedroom that he had been staying in before he was evicted.
Okay.
And he stayed there until law enforcement returned.
Okay, I think I've got it now. All right, thank you for that point of clarification. At this time, defendant will receive a $500 surety bond. It's gonna be it's gonna be $1,000 surety bond. I apologize. It is going to be 500 on each count. And he is to stay away from the incident location, have no contact with Mr. Casey, and have no alcohol, drugs, or weapons. So it should read 500, count one, 500, count two, for the total of 1,000 surety. He will be reset to state on purpose on May the 30th as well. Is there anything further?
Can you clarify the address of the location, please?
What's the address, Ms. Young?
It is 1960 North Avenue Northwest, Atlanta, Georgia.
All right. Is there anything further from state or defense?
Nothing from the state.
All right, sir, I see you raising your hand. Please don't say anything that will be used against you by the state. What is your question?
Now, that really might be about the life.
I lost everything I owned in the rain yesterday. And I'm just looking to move forward and move on with my life. Like, I'm requesting if I can get a signature on. I have no reason to ever go there. I lost everything yesterday.
Okay, I understand the bond will remain in set at this time, okay? And I do understand your position. All right, best of luck to you, sir.
Position number 14, Mort.
All right, Mr. Martin, your case is 23 CR 00312 In this case, you're charged with 2 counts of battery family violence with the offense date of May the 15th. Do you understand your rights?
And say that again, Your Honor?
You understand your rights?
No, I didn't hear what I was accused of.
You're charged with 2 counts of battery family violence.
Okay, I don't know why two. I probably didn't.
Okay, no. I'm not asking you to dispute the charges. I'm asking if you understand your rights. You have a right to remain silent. You have a right to an attorney. That's all I'm asking. You understand those?
Yes.
Okay, thank you. All right, Mr. Howard, please proceed.
18 total. 2017, a fugitive arrest, failure to appear, probation. 2016 DUI, domestic battery DV conviction, and a 2016 simple battery DV dismissed.
Okay. All right, Ms. Reddick.
Your Honor, this incident occurred on May 15, 2023, approximately 10 p.m. at 365 Morning Dew Circle in Roswell, Georgia. Your Honor, it's noted that this is not the first time that evening the officers went out to this location, but at this time they had responded. When they arrived, they met Mr. Jason Griggs, who advised that he and Ms. Christina Nichols were attempting to walk their dogs. They encountered the defendant at the bottom of the stairs. The two asked the defendant to move. The defendant responded, "I don't have to take expletive from you." And then he approached Mr. Jason Griggs and headbutted him, causing his lip to swell and his mouth to bleed. A fight ensued, during which Ms. Christina Nichols was kicked in the calf and hit on her hand by the defendant. Officers noted that there was a swollen lip on Mr. Jason Griggs. They also noted scratches and visible injuries on Ms. Nichols' hand and her calf. All the parties reside together as roommates at this location, which is why it has been upgraded from simple to battery to family violence. Your Honor, this defendant is definitely a flight risk. He has previous STAs as well as had a fugitive warrant. We believe he is a risk to reoffend, as he had a previous family violence battery in Georgia in 2016 and had a previous, the family violence battery in Georgia was dismissed. However, he was convicted of domestic violence in Florida as well in 2016. We don't believe he has sufficient ties to communities. Respectfully, Your Honor, we are requesting a $3,000 surety bond on each count. No further contact with either victim, Jason Griggs or Christina Nichols. Stay away from the address at 365 Morning Dew Circle in Roswell. 1-day anger awareness, no alcohol, drugs, or weapons.
Okay, is Mr. Griggs or Ms. Nichols present and wishes to make a statement? Hearing and seeing none, Ms. McLeod.
Yes, Your Honor. My client is 52 years old. He tells me that he is gainfully employed as a dishwasher. He denies that he was the primary aggressor in this case, Your Honor, and also tells me that he was violently attacked by Jason for no other reason than that he told him, that they were saying, get out of the way, and he argued about that because he was doing something and they had a fight. He said that was the second time that the police had been called out there, Your Honor, because they seemed to have some kind of issue. He tells me that he had an agreement with this couple, their boyfriend and girlfriend, apparently. They rented him a room in their house. He gave them the very last money that he had, Your Honor, $600 for the rent. He's only been there for a week. He tells me that he has no other money and no one that he can call to help him make bond. We do understand that he does have some history, Your Honor, but he tells me that he is in no position to pay for a bond, that if he does not receive a signature bond, he's going to just sit in court. So I would ask the court to take these facts into consideration in setting a bond for him. $3,000 surety bond is certainly not within his range. As he tells me, he has absolutely no money for bond. Nothing further, Your Honor.
Okay. Thank you, Ms. McLeod. Defendant will receive a $1,500 surety bond, 1,000 count 1, 500 count 2. He is to stay away from that location and have no contact with either of the alleged victims. He can return one time with law enforcement to get any of his items. Additionally, he is to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
Nothing further, Judge.
All right, I see you, Mr. Martin, with your hand up as well. And again, if you dispute the facts, that's not why we're here today. Do you have a question about the bond? What is your question?
I have no money to do anything, so I can't flee. I just.
Okay, I understand your position. I understand your position as I've understood everyone's today. The bond will remain as set. You will be reset to state all purpose in 2 weeks. You do not be able to make this bond. All right, best of luck to you. Who do we have next?
Position 18, Price.
All right, Mr. Price, your case is 23 CR 0031198. This case, you're charged with criminal trespass and theft by shoplifting. Do you understand, right?
Yes, ma'am.
All right, Mr. Howard.
33 total. Last arrest was 2020 shoplifting. 2018 escape conviction. Possession of drugs conviction, 2018. 2016 domestic violence conviction. 2011 grand theft conviction. 2010 breaking and entering conviction. And the 08 theft by receiving conviction. That's it.
Okay, thank you. Mr. Young?
Your Honor, on May 16, 2023, the defendant entered Walgreens located at 595 Piedmont Avenue Northeast in Atlanta, grabbed candles, soap, and some detergent before proceeding to walk out of the store. He was detained briefly by a Georgia peace officer. State's recommendation is $1,000 surety. That's $500 on each. No alcohol, drugs, or weapons, and stay away from Walgreens.
What was the alleged value of the items he took?
They were under $1,500. The value was, give me just a moment, pull it up. I believe it was, if you want to let defense go and I can circle back with the amount.
That's fine. All right, Ms. Armstrong, please proceed.
And I think it was between $40 and $50. But my client reports being homeless. We do understand and acknowledge the criminal history, but due to his complete lack of finances and lack of housing, we're asking Your Honor to grant a signature bond in this case.
Okay.
Your Honor, the total, I'm sorry.
Go ahead, I'm ready.
It was $58.19.
Okay. All right. Defendant is going to receive a split bond on the criminal trespass. He will receive a SOB through the jail. And on the theft by shoplifting, he will receive a $50 cash only bond. Is there anything further? All right. Oh, and he must stay away from that, the Walgreens on Piedmont. Have no alcohol, drugs, or weapons.
What was the amount?
I'm trying to.
Okay, so he gets $1,000 SOB through the jail on the criminal trespass, and he gets a cash bond of $50 on the theft by shoplifting. Is there anything further? All right, best of luck.
Ma'am, I didn't mean to cut you off. What is it? What is it? What do I need now? I don't understand the part.
Okay, Ms. Armstrong will explain it to you, okay? We've got to keep moving.
Go to the phone. Oh, you got it? Okay. Thank you, Your Honor.
All right, best of luck to you.
Thank you, Ms. Armstrong.
Position number 19.
All right, Mr. Ridley, your case is 23 CR 003117Y. You're charged with battery, family violence with the offense date of May the 16th. You understand your rights?
Yes.
All right, Mr. Howard.
This is 8th arrest. Last arrest was back in October, simple battery DV. It's 22 CR 007349Y. 2018 possession of meth. 2011 contributing to delinquency of minor. That's it.
All right, Ms. Young. I'm sorry, Mr. Young. I apologize.
Yes, Young. This happened on May 17, 2023 at 994 Capitol Wood Drive, Southwest. Law enforcement arrived and spoke with the victim, who stated that her living boyfriend accused her using his debit card without permission and struck her with a can of beer, causing a knot on her leg. The state does have some concerns as that 22 CR 007349Y case. That's an active case. It's an open case where he struck the victim with a stick in that case and has bond conditions that are still in place per Judge Mincy, which includes no further contact with the victim and to stay away from that address. He's out on a $3,000 good bond. Furthermore, the defendant also has arrest in Alabama that includes a domestic assault going all the way back to 2001 and an assault in 2002. Therefore, we believe that this defendant has a serious likelihood of reoffending given his history, the current conditions he are violating by being at their residence. So the state's recommendations are $5,000 cash bond only. Stay away, no further contact, no alcohol, drugs, or weapons. And we'd also ask the court to sound for Ms. Tara Winkfield when appropriate.
Okay, is Ms. Wingfield present and wishes to make a statement? All right, hearing and seeing none, Ms. McLeod.
Yes, Your Honor. My client is 44 years old. He is gainfully employed. He tells me that he does renovations. He denied that he was aggressive towards the alleged victim, Your Honor. In fact, he tells me that he was just asking her about a transaction which he saw in his Cash App, and she called the police, but he denies that he touched her at all, Your Honor. He does tell me that he has somewhere else that he can go. He doesn't have any money to pay a cash bond, Your Honor, so I would ask the court to consider giving him a surety bond so that he can get out of jail and get back to working.
Defendant will receive a $4,000 surety bond. He's to have no contact with the alleged victim, stay away from the incident location. He can return one time with law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons. Anything further?
Nothing further.
Nothing from the state.
All right, best of luck to you, sir. Who do we have next? Okay, you have a question. What is your question?
They say when they came up, I had
Please do not discuss the facts of this case, Mr. Ridley. This is not your trial.
All right, best of luck to you, Mr. Ridley. Who do we have next?
Position 1, we're trying to clear the courtroom, stand by.
Is that the last position on the calendar, or we have other?
No, we just actually cleared the court when they trying to get him back upstairs so he can be transferred back to the facility he came from.
Okay, can we stop the live stream, please? All right, Mr. Allen, your case is 23 CR 003103D. I won't sound this charge with the offense date of March the 29th.